Hello and welcome to episode 74 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
I'm Joanna Barron, Executive Director of the CCF.
And I'm Christine Van Geyn, the CCF's Litigation Director.
In today's episode, I'll tell you about a new report on the millions of dollars that the Trudeau government is handing out secretly to activist groups to sue the Trudeau government.
And I'll tell you about how arguments went at the Supreme Court of Canada this week in a case called R v. Singer, which is about when the police are allowed to go onto your private property.
And we'll share a bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I want to talk about the latest free speech restricting bylaw from a municipality, which are coming at us fast and furiously. So this one is down in St. Catharines, Ontario, and we've talked before about how there must be something in the water in Niagara region because they're constantly doing dumb and unconstitutional things. For example, it was Niagara Regional Council that declared an emergency last year for a predictable solar eclipse. Anyway, what City of St. Catharines has done here, which is in the middle of a provincial election, no less, is place new unconstitutional limits on election lawn signs. And residents can now be fined up to $5,000 for placing lawn signs on non-residential properties, so, businesses or strip malls or industrial properties. And bylaws can just take the signs without asking. And the only exception for those, businesses and industrial properties is signs inside the interior windows of the businesses or factories or whatever. And for residential properties, so houses, residents are limited to one sign per lawn. And there's some obvious problems with that. Think about people that live together but support different candidates. Shouldn't they both be able to show that with a lawn sign? Here in my own riding, Toronto Danforth, there's a house nearby that always puts both the Green Party lawn sign and the Communist Party lawn sign. And I assume that's a very interesting, civically engaged couple. But under this bylaw, if they lived in St. Catharines, they'd have to choose between a candidate who supports overthrowing the bourgeoisie and taking over the means of production and the candidate who just wants to shut down the means of production and turn it into an organic hemp farm. And that's just not right. So anyway, the St. Catharines mayor told the local newspaper this bylaw is needed because too many lawn signs creates a mess. It looks awful. They blow into traffic. I'm not sure I'm buying that, and this isn't the first sign bylaw the CCF has dealt with. So we point out every time this comes up that it's not constitutionally justifiable. For example, Brampton, Ontario attempted to amend their sign bylaw back in 2022. We stepped in and they said they were putting it on hold until they did a consultation. They didn't ever do that consultation as far as we know, and the sign bylaw magically appeared on their website, and now it's disappeared again. And back in 2020 in Yarmouth, Nova Scotia, the town council banned lawn signs entirely, stating that they caused too much plastic waste, too much visual clutter, and that making them illegal was more financially equitable for candidates, I guess. Anyway, Yarmouth backed off after they got this demand letter from Christine, who pointed out some of the constitutional problems with these bylaws. And the main one is that, it's not this idea that people who live in the same house should be able to each have a sign. It's that banning lawn signs tends to favor incumbents. And that's because incumbents have name recognition and voters are more likely to put an X beside a name that they recognize. And putting up lawn signs, it's a really good way for new candidates to, show that they have some momentum and that they can beat the incumbent. And that may be a factor here in St. Catharines, where you have a New Democrat MPP who is facing a pretty strong challenge from the PC competitor. And I'm not saying that's the motivation here. I'm just saying that's, one reason why it matters and why it's constitutionally questionable. And you hear these justifications that, it's about litter or it's about blight, but even in the classic example in the free speech case law of like what's a content neutral restriction and one that's content based, it says that you could potentially ban litter because that's not aimed at the speech, but you can't pass a bylaw that bans pamphlets because that's aimed at the speech itself. That's not going to be acceptable. And with this bylaw, it's actually called the election sign bylaw, and it's specifically about election sign law, as election signs and political speech. So very, very unlikely to be constitutional. Anyway, Christine, I know you've been fighting these bylaws for years. Why do you think they keep happening?
I think it keeps happening because it advantages the people who enact these bylaws. If your opponent cannot advertise and you can pass a law prohibiting your opponent from advertising, reason dictates that you would probably try to do that. Now, the Constitution is supposed to prevent our politicians from gaming that incumbent advantage by passing laws like this, but I think that the problem is this is always at the municipal level, of course, and that our municipalities are governed by these meddling little busybodies who think they know better than everyone else. And that's just, I think, the nature of what attracts a lot of people to municipal politics is that they want to get up in everyone else's business. So that's what they're trying to do. And they always have these kind of colorable reasons. They'll say, oh, it's about the environment. Well, if it was about the environment, like, what if the signs are recyclable? I just do not buy at all that it is about the signs blowing into traffic. Like, give me an example of where there has been a traffic incident because of a municipal or like a provincial election sign. It's not because of that. It's because signs cost a lot and the candidates don't want to have to spend money on a, quote, sign war because they already have the advantage of incumbency. So that is what it's about. I really think that all of these other reasons are absolute nonsense. If it was about pollution, which sometimes they say, they would say, well, the pollution rationale applies for the signs that are still inside windows. Like those are still made of the corrugated plastic that is, so environmentally damaging according to these municipal councilors, but they're allowed in that situation, but not in another one. So I just think it's self-serving, and I do think it's unconstitutional, and I wish municipalities would stop doing it. Joanna?
Yeah, I was just remembering one of the kind of endearing but ultimately annoying things that happened during the Yarmouth incident, which was kind of mid-COVID, which you very effectively wrote them a strongly worded letter and had them back down. But it was kind of cute. We got a letter from this obviously older gentleman who was a Yarmouth local lawyer, and it was dictated by his secretary. And he was very gently mansplaining to us why the charter did not apply to the decisions of Yarmouth to ban election signs. And I can't remember exactly what his rationale was because it was a few years ago, but he was basically like, we can do what we think is right for Yarmouth. And no, the charter still applies to you. You are still...
He was making some argument that they needed to have their own notwithstanding clause within the bylaw. It was out there. It was out there.
Yeah. So anyways, but yes, that is not correct. That is a bad legal take, even though I know we're on the BLT section. But it seems to be that gentleman in Yarmouth is not the only one who is harboring this delusion. Christine, you want to talk about yesterday's big hearing?
Yeah, so we were in the Supreme Court of Canada yesterday as an intervener in a case called R.V. Singer. The question in that case is, can police enter your private property, look in your car window, open your car door, and collect evidence from inside your car, all without a warrant? And the police were saying in that case that they could do that. The Crown prosecutor was saying that the police can do that. And we were arguing that no, the police cannot do that, at least not under a doctrine called the implied license. So they said they had an implied license to enter the property and do these things. Now, an implied license is a doctrine that's established by common law, so by the courts, and it says that the police can, or anyone, any person, can approach a home for the purposes of communicating with the person inside, for example, by knocking on the door. So the police can come up to your door and knock on it and see if you're home. You know, your local Jehovah's Witnesses can do that. Your local municipal election candidate can come and do that. Your Amazon delivery guy can come and do that. People can come and knock on your door. But how wide is the scope of that power? They can knock on your door. Can they look in the windows? Can they open the door of a vehicle on your property? We don't think so. Like if I saw somebody on my property looking in my car window and then opening my car door, I would call the police. And if it was the police doing it, I don't know who I'd call. I'd be really sketched out though. So let me explain the basic facts of the Singer case. Basically, what happened in that case, it was from rural Saskatchewan. The police received a phone call reporting a suspected impaired driver. The police went around the community looking for the vehicle, and they found one matching its description, but it was parked on a private driveway. They could see that it was running, but they couldn't see if there was anyone inside the vehicle. Now, the property belonged to a man named Wayne Lester Singer, and he, as it turned out, was inside the vehicle, passed out, and he failed a breathalyzer test or a breath test that was subsequently done on him. Now, to be clear, just because the police see a vehicle on a driveway running, that does not meet the criminal standard that is required for a search. It is not what the law calls reasonable and probable grounds that a crime has been committed. It is not even reasonable suspicion. It's basically police intuition or a hunch based on, you know, a very vague information, a bare tip from the public. So the police had a hunch about this car. They didn't have a warrant, but they decided even without a warrant, they were going to walk up to the car, onto the property, up to the vehicle on the driveway, look inside. And when they looked inside, they saw a man who turned out to be Mr. Singer passed out. They knocked on the window. He didn't wake up. So they opened the vehicle door. They shook him awake. And when they opened the door, they smelled alcohol in the car. He was given that breath test, which he failed, and he was charged with impaired driving. So the question is, was this a search? Was it reasonable search? Should the evidence from the breath test be excluded? Or even the evidence of the police, smelling the alcohol? So I just want to be clear that impaired driving, I do not endorse impaired driving. It's a really serious problem in society. People die from impaired driving. It's illegal. It's a criminal offense. I do take it seriously. I also take the Constitution seriously. And I do not think that the police had the power to do what they did, at least not under the implied license doctrine, because the implied license is really narrow. It only allows people, including police, to approach onto private property for the purpose of communicating with the occupant. It does not permit opening of doors, looking in windows, and collecting evidence, and then using that evidence to charge someone with a crime. It only permits this limited intrusion. It's often referred to as a police search power. I've called it a police search power just when communicating about the case, but really it's actually not a police power. It's a waiver doctrine embedded in the principles of private property. It actually originates from the common law related to trespass. So the idea is that entry to private property is prohibited. Everyone is excluded unless they are explicitly permitted. So it is a limited waiver of that reasonable expectation of privacy, not just vis-a-vis the police, but vis-a-vis anyone, vis-a-vis, those, like any stranger. And the only time these strangers under this implied license are permitted to enter your property and knock on your door is when there is a customary social norm that dictates that the owner's consent is reasonably presumed in these situations. It's so You don't charge your Amazon driver with trespassing every time he drops off a package. So everyone is excluded unless they're explicitly permitted, or if their permission is implied in these really narrow situations. And because we're talking about this kind of implied invitation, this assumed invitation, we need to have really, really high standards about when it applies, because consent is not supposed to be presumed. It's supposed to be voluntary and informed. And in this case, we can't presume that consent was presumed. No one would consent to the police entering your private property to search your property so that they can charge you with a crime. That is not a reasonable assumption. There is no customary social norm that that people would allow the police to do that. That is just too expansive an understanding of the implied license. The idea that the implied license allows police to walk onto property, peer in windows, open doors, and collect evidence. So that's what we were arguing. We also wanted to emphasize that the narrow scope of this implied license is rooted in the law of trespass and its application to one of the most sacred zones of privacy protected by Section 8 of the Charter, which is the right to be free from an unreasonable search and seizure. And that sacred zone is the home and its surrounding yard. So we have a really, really strong right to privacy in our home. And we want, in this case, to get the court thinking about property, which is an issue that we care a lot about at the CCF, and which is given undue weight, like not enough weight, not too much weight, not enough weight in Canadian law. Now, look, I know that this is a difficult case for a lot of people. I've had some of my friends tell me, like, I don't care, this guy was drunk driving, that's really bad. And I agree that drunk driving is really bad. I hate when people do that. I hate it. I have a friend who was hurt by a drunk driver, and police absolutely should investigate impaired driving, and they should do so using the tools that are at their disposal, not by expanding things like the implied license. So I have a YouTube video where I explain more of the details about the case and some of the origins of the law of trespass and the law of the implied license, and compare it to the American jurisprudence, which is really interesting in this area of law. And I gave a few hypothetical scenarios in the video of what an expansive implied license might look like that are kind of interesting. So an example is, I get in a fight or an argument with my husband, and I just need to calm down and take a break. So I leave the house, I go and sit in my car, and it's cold out, so I turn the car on. If a police officer is walking by, can he just walk onto my property and open my car door and no, of course not. Or what if you are a shift worker, like you're a nurse, and you come home late, you're tired, you have a bunch of dogs at home, like I do, and you don't want to go inside because the dogs are going to wake up, they're going to wake up your kids, it's going to be all hell will break loose. So you end up just falling asleep in your car. Can the police then come and enter your property, open your car door, push you awake, root through your car to find evidence, and then charge you with some crime based on what they find? No, that is not how the implied license is supposed to work. I don't think that the police can do just whatever, even though this guy was charged with impaired driving, and he failed that breathalyzer test, which is bad. But I just don't think that the police can do whatever they want in the name of prosecuting crimes. This is not a totalitarian state. Police need to use the powers they have in compliance with the Constitution in order to prevent those powers from being abused against innocent people, like in those examples I just gave you. So this is to prevent random searches of private property, and to prevent that, we need to have a threshold to enter property, and the implied license just is not part of that threshold. So I really hope that the court can clarify how narrow this exception is, because if this exception to enter private property and search around is opened up, I just do not like where we are going as a society. Now, Joanna, you practice criminal defense law. I know what people are going to say, that, if this power was expanded, we should trust the police to use it reasonably. They wouldn't just go door to door, peeking in windows, opening doors, just because they have the power to do so. I know you've had interactions in that role as a criminal defense lawyer with police. What do you think?
Yeah, well, I think the important thing to emphasize is that these scenarios where this law is tested always come up in a scenario where we're not particularly going to like the facts, right? Where an arrest was made, and that is why the accused is challenging the law. Otherwise, these laws are never tested. Now, you could say conversely, well, how else are you going to catch drunk drivers? But actually, in this case, in many areas of criminal law, it is true. Like, how are you going to catch a terrorist until you catch a terrorist? But there are extensive ride programs on the highway in, all over Canada. And so people who haven't yet crashed a car drunk or caused any harm, they get caught all the time. And ride programs are kind of like acceptable balance between privacy rights of the accused and investigatory police powers. And I think that's a reasonable balance given the scourge of drunk driving. This is, an expansion. And as you mentioned, we have this constitutional architecture where we also have to balance, in this case, the fact that there was a trespass onto private property. And so, the balance is just, I think, inappropriately tilted. I don't know, Josh, if you have anything to add or what you think.
Yeah, I'll just add this. Uh, our laws become really messed up on Section 8, and that's because of a case in the U.S. Cats, where the U.S. court said, oh, this Fourth Amendment, which is basically very similar to our Section 8, protects people and not places. But you can't actually protect the people in most, search cases if you're not respecting the property rights, you're not respecting the place. And the reality is that in both Canada and the US, these sections originated in cases where the king, or actually, yeah, in both cases, it was the king or the king's messengers was intruding on people's property. And the one case that we quote, that's sort of the famous one from England, called Entick and Carrington, where the king was sending his messengers after people that were publishing newspapers he didn't like. The court found that, to quote this very old case, our law holds the property of every man so sacred that no man can set his foot upon his neighbor's clothes without his leave. If he does, he is a trespasser. Though he does no damage at all, if he will tread upon his neighbor's ground, he must justify it by law. And so that's the type of thing we're trying to point out to the court here, that yes, it protects people, not places, but often you also have to protect the place. And the seminal case in Canada on Section 8 rights, called Hunter and Southam, actually could not be more clear that this is the case. And so that's why we're there. That's why we're at the court making this argument, because people like to say in Canada you have no property rights, and we don't. Perhaps we don't have like explicit property rights, but we do have a right not to face unreasonable searches in our homes, not to have the state come and intrude unless there's reasonable and probable grounds that some sort of crime has been committed. So that's all I'll say about that. Joanna, you have a really interesting headline to talk about this week. Let's do that.
Yeah, so we were really excited to see a report that was published last week by the MacDonald-Laurier Institute by our friends, Professor Dave Snow of the University of Guelph and Professor Ryan Alford of Lakehead University, Boer Alaskan Law School. And it is a new explosive report that exposes how our taxpayer dollars are being used to wage social justice battles through the courts. So we're talking about the Court Challenges Program, somewhat ironically shorthanded as the CCP, and what this report reveals about the role that it has in shaping our politics through publicly funded litigation. So this program has been a political football for decades. Ian Brody called it that. It was created by Pierre Trudeau in 1978. It's been canceled by conservative governments and then revived by liberal governments. And Justin Trudeau brought it back in 2017. Now it is distributing between $3 to $5 million per year to fund organizations and individuals who want to pursue constitutional litigation. So that sounds pretty unobjectionable at first glance, helping citizens access the courts to protect their rights, which the CCF does, albeit with zero public funding, just to be clear, but sounds like a good thing in principle. But here's where it gets interesting. Snow and Alford's report analyzed 6 years of data, and what they found is quite striking and unequivocal. 96% of the program's human rights cases funded progressive activism, and there were literally 0 cases supporting anything that could reasonably resemble a conservative position. So here are some examples. There was a case trying to expand federal healthcare coverage for irregular migrants. There was another pushing for more generous disability benefits. They funded interventions defending the federal carbon tax, and they even funded legal support for 2 people who were seeking refugee protection after they were found to have committed crimes against humanity while serving in Mugabe's army in Zimbabwe. So crimes against humanity, Trudeau government funding their human rights claims. So the report identifies 3 major problems with this program. First, lack of transparency. Most of the recipients are kept secret under litigation privilege, so Canadian taxpayers can't even know who's getting our money most of the time. Second, it's being used to argue overwhelmingly in favor of centralizing federal power over provincial power by funding cases against provincial governments, which is particularly galling and controversial in the light of the fact that the Constitution requires Canadian federalism. And third, of course, as I mentioned, it is just overwhelmingly, excessively biased towards progressive causes. But then from a governance perspective, this also raises fundamental questions. This allows the federal government to achieve its preferred policy changes indirectly and sort of with an invisible hand through the courts rather than through legislating. So instead of changing laws through Parliament, where there would have to be public debate, scrutiny, adversarial debate, they're funding litigation to challenge these laws in court. So they're using taxpayer money, literally, to sue themselves. But the outcomes can have far-reaching implications for Canadian society. So it's very sneaky. So just to talk for a minute about some of the specific cases that the report gets into. There's a case called Seklani that tried to expand a controversial loophole allowing asylum seekers to bypass regular border crossings, which of course had been a huge bugaboo and caused huge controversy and strain on Quebec's social services. There is a case challenging the minimum income requirement for immigrants to sponsor their parents and grandparents. That's a case called Beejam v. Canada. And I was also interested to learn, and Josh and Christine, you'll probably be interested if you didn't read this, that the CCP also funded a group of First Nation bands to intervene in power, which we also intervened in. That was the case about damages against the government in exceptional cases for unconstitutional litigation. But this publicly funded intervention was for an argument that contemplated claims for damages on a scale previously unimagined, claims for damages against Parliament for having enacted the Indian Act, for example. And so just to underscore again, what is particularly concerning, according to Snow and Alford, is how this affects public trust in the judicial system. And when you have a federal government program that exclusively funds progressive causes, it can create the impression that courts are just another political arena rather than the independent arbiters of the rule of law, as they should be. And courts are, of course, supposed to be above the political fray. So to conclude, Snow and Alford muse about whether this program could be reformed to be more ideologically balanced, maybe bring in some transparency reforms. But they ultimately say you don't need to fix the program, you just need to kill the program. They say the CCP has to be done with. The process of selecting which rights claims to fund is inherently political, so there's no way of getting around this program. And they conclude that this program has outlived its usefulness and should be shut down, not just because of the progressive bias, although, of course, that's a major issue. It's about how this program fundamentally changes the relationship between courts, parliament, and the Canadian people. So, Josh, what do you think about this? Do you think that we should be using taxpayer money to fund litigation? We like public interest litigation. And what do you think about this sneaky maneuver of funding court challenges, the government funding court challenges to their own laws?
Well, I testified in Parliament about this, and my position is that it needs to be shut down. It's not a reformable program, and it exists for sneaky reasons, quite frankly. And the little that we do learn about these cases that, Ryan and Dave have laid out here is that they support almost 100% one side. So it's just throwing weight under the positions of the liberal position, essentially, and that's just not right. It's also a bit of a boondoggle. I mean, in some ways, these are small numbers. We're talking $3 to $5 million a year, but they're paying over $1 million a year to administer this program. That seems like a lot of money to decide, which lawsuits you're going to fund with taxpayer dollars. And the amounts that they give out are really substantial. You can get $20,000 to develop a case. You can get $50,000 to do an intervention. You can get $200,000 for the litigation itself. And, I spend a lot of time, Christine, all of us, we spend a lot of time developing potential cases, and we don't get paid anything to do that. And a lot of the interventions, we have to rely on the goodwill of, outside lawyers doing this pro bono because they want to help out a charity, because litigation is very expensive. It would be amazing to get $50,000 to do an intervention. I'm working on one right now myself, and it's a lot of work, but we have to rely on donors. So anyway, it would be nice to have this money, but not worth it in our particular case, since we don't want to be corrupted like some other groups. Christine, you've written a lot about this. What do you think?
Yeah, so we don't just rely on donors, we also rely on the generosity of counsel. So a lot of our lawyers are really interested in these issues, and they're excited to work on them as a public service, that a lot of lawyers do this at a reduced rate or a pro bono rate. And it's crazy to me that there's this cottage industry on the left of developing cases for money and running these cases for money, and then the government pays you to do all of this, when our perspective on this is so radically different. And there was a private member's bill a few months ago to make this program permanent, to incorporate it into legislation, so that it's harder for a future government to remove it. Because I can tell you one thing for free: if Pierre Poilievre is the next prime minister, this program is absolutely toast. Like, there is going to be no public support for this case. The campaign attack ad writes itself. It's like the Trudeau government paid these public interest, so-called public interest organizations to intervene in not in a challenge, like to support the government's position. They're just like, bootstrapping their own position with our money and saying it's through this court, and doing it through this court challenges program, and saying it's all about public service, public interest, and then the case of the crimes against humanity individuals. I mean, that is literally an attack ad. How many Canadians who can't afford to properly feed their families or pay for their mortgages or pay for their rent are like, but sure, send my tax dollars to some former Mugabe crimes against humanity dudes. They really need that money. I'm willing to give up a little bit to help that guy. Give me a break. Like, this is some of the it's crazy to me that any money would be spent on this at all, let alone in cases this offensive. And remember, the people who select the cases, there's a committee that chooses the cases that will get funding. And that committee is selected by the Minister of Heritage. So they do not draw on the conservative intellectual class to help choose these cases. So it should be no surprise that they are drawn almost entirely or entirely from progressive causes and progressive organizations. I wish that could be my bad legal take, because it's just so insane. The existence of this program has bothered me since I found out about it, whatever, like whenever I became politically aware back in like 2006, I think, was when Harper might have canceled the first version of this when he was first elected prime minister, because it's such a bad program. But my bad legal take instead is going to go to a guy on Twitter. And I'm going to try and not be too mean, because like, I get where he's coming from. So he posted about the possibility of Mark Carney winning the Liberal leadership race and becoming prime minister, even though Mark Carney does not currently hold a seat in the House of Commons. So this person said that this could be a violation of Section 3 of the Charter, which protects our voting rights. And he wrote, and I'm quoting here, "I'm obviously not a constitutional lawyer, so take this with a grain of salt, but Mark Carney trying to become prime minister through a Liberal leadership race before attempting to secure a seat in Parliament presents a very real Section 3 challenge, at least in my smooth brain opinion." So, he had a caveat in there. I give him credit that he is admitting that he doesn't know how this works. And intuitively, I do understand why he feels this is undemocratic. I share that view. It does not feel good. It does not feel democratic that our prime minister, the man who may become our prime minister for some short period of time, never won a seat, never won a single election. But that is simply a feature of the system we have. We do not directly vote for our prime minister. And I also want to be fair to this guy, because there are crazy activists who argue all kinds of crazy things about Section 3, probably funded through the Core Challenges program. I don't know. I wouldn't be surprised to see that. So we've been involved in a case where some activists say that Section 3 of the Charter makes the first past the post system unconstitutional because there are wasted votes. It's not unconstitutional, but neither is this situation. But like, I get why he might think it is, because it seems undemocratic, doesn't feel good. And activists argue the Section 3 does all kinds of things that it doesn't actually do. So he might have seen that somewhere. So to be clear, this is not a violation of Section 3 of the Charter, and it isn't even a new scenario. This has happened a bunch of times. So this is kind of a fun opportunity to look at a little bit of Canadian history, because there have been a few instances where individuals became prime minister without immediately holding a seat in the House of Commons, or not currently holding a seat in the House of Commons, but they did manage to secure a seat shortly after. So it's practice that where a prime minister is selected without a seat, he or she is expected to seek election in the House of Commons as soon as possible. Typically, that would be through a by-election or the next general election. But there isn't a strict legal requirement. It's just that political practice and practical necessity of, actually representing people in the House of Commons and participating in parliamentary debate kind of drives this customary practice. So there are a bunch of examples from history, like John Turner became the Liberal Party leader without holding a seat in Commons. He was appointed prime minister in June of 1984, succeeding Pierre Elliott Trudeau without holding a seat at the time. He did seek one after, although I think he lost the general election basically immediately. His party lost the general election. There was also William Lyon Mackenzie King. He was actually one of Canada's longest serving prime ministers, and he lost his seat in the House of Commons in the 1925 federal election, even though his party formed government with the support of other parties. He continued as prime minister without a seat for a short period, He governed from outside the House, and he quickly ran in a by-election and secured a new seat within a few weeks, allowing him to return to the House. And that situation actually repeated itself in 1945 when he again lost his seat but remained prime minister and won a by-election shortly after. So there have also been scenarios in provincial politics where premiers were appointed or selected as leaders of their parties without immediately or currently holding a seat in the provincial legislature. But they did secure seats shortly after. And there's a bunch of modern examples, like in 2013, BC had a general election. Christy Clark's Liberal Party formed a minority government, but she personally lost her seat in Vancouver Point Grey. She continued as premier without a seat for 56 days until she won a by-election in Kelowna. Then Danielle Smith became the leader of the United Conservative Party in Alberta and was sworn in as premier in October of 2022 without holding a seat in the Alberta legislature. She hadn't run in the previous election, but she did quickly secure a seat by winning a by-election in Brooks Medicine Hat in December of 2022, just a few months after becoming premier. So this isn't new. I sympathize that this isn't an ideal scenario, but it isn't unconstitutional. It's happened in all of these cases. It's just a feature of our system. I think the more interesting scenario is if Carney becomes the Liberal leader, becomes the prime minister, but doesn't immediately seek a seat, either by trying to go through a by-election or calling a general election. That would challenge the convention that the leader seeks a seat if he or she doesn't hold one, and they seek it immediately. A challenge to that convention raises more interesting questions than whether or not this practice violates Section 3 of the Charter, which, of course, it doesn't. Josh, what's your bad legal take this week?
So my bad legal take goes to the University of Alberta, which has a nursing course called Indigenous Health in Canada that's been described by one of the students, excuse me, in an email to Quillette's John Kay as, quote, 4 months of self-flagellation led by a white woman. And the bad legal take is that this course, which is mandatory to become a nurse, requires students to, quote, commit to concrete actions to disrupt settler colonialism, and requires students for grades to write a land acknowledgement. And normally what happens in universities is not covered by the charter, rather it's covered by academic freedom. And so that means the student, could complain that their free expression or conscience rights are violated by, this attempt to require professing one's faith to the woke religion. And that might be, reviewable by courts if they're disciplined for it, but generally the charter is not going to apply to the type of decision to, force this course on students. But in Alberta, courts have found that because of the way the statutes are set up to create the universities there, in some cases, they may be implementing a government program when they teach a course like nursing. And so your Section 2A conscience rights and Section 2B freedom of expression rights might come into play, in which case this would be a charter violation. So, universities shouldn't be surprised if they start seeing legal challenges against this sort of very bad legal take that nurses can be required to commit to, what's the wording here? Commit to concrete actions to disrupt settler colonialism when that's against their actual view or conscience rights. But anyway, to me, the bigger problem here is just the fact that nurses are quitting in droves, new nurses, because they're unprepared to deal with patients. And there's shocking statistics about this. In Quebec, I think it's up to 30% are quitting right away. I was talking to a neighbor who's a nurse, and she said everyone's quitting right away. My mom, who's a former nurse, has observed this. The problem is that nurses are no longer getting the skills they need in nursing school to be actually able to deal with real patients when they get to a hospital. And so to me, the bigger problem here is just that this is wasting everyone's time because it's not actually teaching nurses the skills they need. Joanna, let's hear your bad legal take.
My bad legal take of the week goes to Margaret Brennan of CBS on Face the Nation last weekend in an interview with Secretary of State Marco Rubio. She claimed that the Nazi Holocaust occurred because of free speech, because free speech was weaponized in Germany, and this was in the course of denouncing Vice President J.D. Vance's comments at the Munich Security Conference about Europe's draconian restrictions on speech. And whatever you think about J.D. Vance's swashbuckling approach to the Europeans, recasting the whole Holocaust as a consequence of excessive free speech makes no sense. This is very historically ignorant. There is a name for this false claim, which is the Weimar fallacy, which is the claim that if the Germans had just done enough to censor the burgeoning Nazi movement, that maybe Hitler wouldn't have come to power. But on the contrary, there were fears about the rising Nazi influence, which caused Weimar Germany to take increasingly heavy-handed authoritarian steps to outlaw and censor Nazi speech during the 1920s. They shut down hundreds of Nazi newspapers. In a 2-year period, they shut down 99 in Prussia alone. That is from an excellent paper by Greg Lukianoff of the Foundation for Individual Rights and Expression. He also wrote that they accelerated, the Weimar Republic accelerated that crackdown on speech as the Nazis ascended to power. And Hitler himself was banned from speaking in several German states in the 1920s. And Nadine Strossen, the former president of the ACLU, who I had the great privilege of interviewing in a fireside chat at the Runnymede Society's conference 2 weeks ago, also found that there was no usefulness to aggressively censoring Nazi speech. And instead, the German government actually failed to take appropriate action to curtail the physical violence that the Nazis were doing in the street. And so, sorry, Margaret Brennan, but it was not free speech that caused the rise of the Nazis. You get my BLT this week.
Yeah, great bad legal take. We actually talk a little bit about that in our free speech book, which is on Amazon. You should get your copy if you haven't already. I think that's pretty much it for the podcast. I just want to say though, before we go next week, I will be away, so we will have updates from Christine about our Calgary bylaw challenge instead. And as usual, I'll ask you to rate us, review us, and subscribe. And you can support our work by subscribing to the CCF's YouTube channel, following us on Twitter, or visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter from our colleague Russ. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.